fulfill a payment, and create barriers to successful reentry after an offense. 4C Conference of State Court Administrators, 2011 to 2012 policy paper, Courts are not revenue centers. As court leaders, your guidance on these issues is critical. We urge you to review court rules and procedures within your jurisdiction to ensure that they comply with due process, equal protection, and sound public policy. We also encourage you to forward a copy of this letter to every judge in your jurisdiction to provide appropriate training for judges in the areas discussed below, and to develop resources, such as bench books, to assist judges in performing their duties lawfully and effectively. We also hope that you will work with the Justice Department going forward to continue to develop and share solutions for implementing and adhering to these principles. First, courts must not incarcerate a person for non-payment of fines or fees without first conducting an indigency determination and establishing that the failure to plea offense to incarceration, because that would subject him to imprisonment solely because of his indigency. Williams v. Illinois, 399 U.S. 235, 241-42, 1970, holding that an indigent defendant could not be imprisoned longer than the statutory maximum for failing to pay his fine. The Supreme Court recently reaffirmed this principle in Turner v. inquires anew into the reasons for the person's non-payment and determines that it was willful. In addition, to minimize these problems, courts should inquire into ability to pay at sentencing when contemplating the assessment of fines and fees rather than waiting until a person fails to pay. Mundram, under Bearden, standards for indigency inquiries must ensure fair and accurate assessments of defendants' ability to pay. Due process requires that such standards include both notice to the defendant that ability to pay is a critical issue and a meaningful opportunity for the defendant to be heard on the question of his or her financial circumstances. See Turner, requiring courts to follow these specific procedures and others to prevent unrepresented parties from being jailed because of financial incapacity. Jurisdictions may benefit from creating statutory presumptions of indigency for certain classes of defendants, for example, those eligible for public benefits, living below a certain income level, or serving a term of confinement. See e.g. R.I. General Laws, Section 12-20-10, listing conditions considered prima facie evidence of the defendant's indigency and limited ability to pay, including but not limited to qualification for and or receipt of public assistance, disability insurance, and food stamps.
Pay attention. So if you're on social services or DSS or whatever you call it in your state, you're getting public assistance, they're not supposed to have you on child support. Now, I know that they do that for people that are incarcerated, even though there are some people that they still take the money from them while they're incarcerated. But the thing is, they're not supposed to. If they're incarcerated, they're not supposed to be paying. If they're on public assistance, they're not supposed to be paying. And they have to figure out, they can't just suspend it and hold it over your head until you got work or whatever. No. They have to bring you back, reevaluate your situation, and figure out another method, whether it's public service, doing some acts for the public, or it's for they're gonna extend your, not gonna extend your time because they don't know when you're gonna be gonna be making more money. So they have to modify whatever conditions you have for that child support, or traffic tickets as well, people. This applies to traffic. So I'm kind of focusing on child support more so than traffic, but it pertains to the traffic joints as well, and other charges. Okay, so if, say for instance, they give you court fees and stuff like that, you lose your case for whatever charges you may have had, and they want to implement court fees on you and stuff like that, they have to defer it or figure out some other kind of way to get that money out of you outside of excluding locking you back up. All right, locking you back up, or adding interest on top of what you owe. They're not supposed to do that. They can't do that. This right here puts the nail in the coffin for these organizations, these companies that we think are courts, these companies, these businesses that are basically raping people through that system. So let's go back into it, and please pay attention.
2. Courts must consider alternatives to incarceration for indigent defendants unable to pay fines and fees. When individuals of limited means cannot satisfy their financial obligations, Bearden requires consideration of alternatives to imprisonment. 461 U.S. at 672. These alternatives may include extending the time for payment, reducing the debt, requiring the defendant to attend traffic or public safety classes, or imposing community service. CID. Recognizing this constitutional imperative, some jurisdictions have codified alternatives to incarceration in state law. See, e.g., Georgia. Code and Section 42-8-102F-4-A, 2015, providing that for failure to report to probation or failure to pay fines, statutory surcharges, or probation supervision fees, the court shall consider the use of alternatives to confinement, including community service.
I hope you caught that. Probation. Don't forget parole is included to that. Throw parole in there also. All right. So now if you fail to report or something like that, it's not automatic violation. You get locked up again. All right. They have to come up with other solutions as opposed to just locking you up. Now, listen, this document, the courts received it, but they're acting as if they did not receive it. Okay. So what we're doing is, I got my copy right here next to me, and I got multiple copies right now. I'm in front of Staples, and I'm getting more copies made because I'm going to take it. I'm going to serve one on the county recorder's office, serve one on the court, whatever, traffic court, and the criminal court. All right, serve it on them. Serve it on them. Why? Because as soon as they bring you in, or your record, your file's going to come up. If they ever bring you in again, your file's going to come up. And what's in your file, they can't get around it. It's already there. And what happens? Case dismissed. They don't want to deal with you. They don't want to deal with this because now they cannot fall back on plausible deniability. They cannot fall back on plausible deniability. They cannot say that they didn't know. It's in my jacket. It's in my file. All right? So, DOJ, Civil Rights Division, dear colleague, and you want to pick the one that says court because there's multiple dear colleague letters, all right, that they send to each other. Make sure you get this document here, dealing with the courts, and you print it out and you serve it on these people. All right, tell them to put it into the miscellaneous file or any file that pertains to you. You know what I'm saying? Bam. All right, let's get back to it.
See also Tate, 401 U.S. at 405, discussing effectiveness of fine payment plans and citing examples from several states. In some cases, it will be immediately apparent that a person is not and will not likely become able to pay a monetary fine. Therefore, courts should consider providing alternatives to indigent defendants, not only after a failure to pay, but also in lieu of imposing financial obligations in the first place. Neither community service programs nor payment plans, however, should become a means to impose greater penalties on the poor by, for example, imposing onerous user fees or interest. With respect to community service programs, court officials should consider delineating clear and consistent standards that allow individuals adequate time to complete the service and avoid creating unreasonable conflicts with individuals' work and family obligations. In imposing payment plans, courts should consider assessing the defendant's financial resources to determine a reasonable periodic payment and should consider including a mechanism for defendants to seek a reduction in their monthly obligation if their financial circumstances.
And that's the end of that, people. All right. Go get the document. Go work on your freedom. Assalamu alaikum to the Muslims. Islam to the Moors. Hotep to the Egyptologists. Namaste to the Hindus. Peace be upon you to the Christians. And good morning to those who are just waking up to this knowledge. Good morning. You're welcome.